Welcome to today's program titled Unpacking and Navigating the DOL's New Overtime Exemption Rule. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE attendance verification code. Please write this code down, as it will not be reread, and it is required on the CLE credit request form. During the program, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Scott Hecker. Scott, please go ahead.
Thanks, Kate. Appreciate it. You'll see the slide there. I'm the guy in the middle. I'm a senior counsel in our DC office. For those of you who haven't worked with Seyfarth before, we are a full-service national and, in fact, international law firm with transactional practices, real estate, IP. We're really built around the businesses our clients are in, the sectors they're in, and we're working with them day in and day out. With me today are two of my brilliant colleagues, Kevin Young, a partner in our Atlanta office, and Ariel Fenster, an associate who's also in Atlanta. We're all from the firm's Labor and Employment Department, and our firm has been doing labor and employment for 85 years. Now we have around 400 lawyers nationwide in our L&E group working to support our clients through all sorts of labor and employment issues. The three of us focus a lot of our practice on wage and hour counseling and litigation. This is obviously one of the hottest topics out there and very, very frequently litigated issues. It's also moving really quickly. We've seen a lot of change, not just the OT rule, but the independent contractor rule and other rules that are coming out and impacting this space, seemingly every day. We all kind of approach L&E from a different perspective, but all with a focus on our clients' goals. I actually came to Seyfarth from DOL. Ariel does a lot of the day-to-day counseling, compliance work with our clients, just kind of on the ground, hands in. And Kevin does a fair amount of class and collective action litigation and counseling. So that's our background. And with that, I'm going to turn it to Ariel to talk about our roadmap for today's presentation. Ariel?
Thank you, Scott. Today, we're going to give a refresher on the Fair Labor Standards Act overtime exemptions as of today. We'll examine the final rule, which is set to go into effect on July 1st. We'll talk about likely legal challenges that will come ahead for the final rule. And then next steps, we'll talk about those business tactics for how you all should really take that final rule and apply it to your businesses. The next slide, we'll begin to talk about what the current rule is today and give a refresher. So I'll hand it over to Kevin for that.
Yeah, thanks, Ariel. Thanks, Scott. And thanks to all you for being here. We're excited to get into it. So we're going to start, as Ariel mentioned, by just giving an overview of where the overtime exemptions stand as of today. Make sure we're on the same sheet of music about what we're talking about with an idea of not just where we're going to, but where we're coming from with this rule. So on the next slide, we've lifted some language from the FLSA, from the statute, and it's not our typical MO to read law at audience participants, but the general idea here is that Section 6 or 206 and Sections 207 of the FLSA impose on the vast majority of employers obligations to pay employees both minimum wage, which is at $7.25 right now at a federal level, as well as overtime, time and a half for any hours worked in excess of 40 in a work week. That said, the FLSA, in its statutory text, also creates exemptions to these requirements. So like we do anywhere in the law, we usually start with the statute. The statute says on its face that the minimum wage and overtime provisions don't apply to employees who are employed in a bona fide executive, administrative, or professional capacity, as those terms are defined by the Department of Labor. This is where the exemptions we're talking about are coming from. You'll hear these exemptions referred to as the EAP for executive, administrative, professional exemptions. You'll hear them referred to as the white collar exemptions. But bottom line, they're coming from this section of the statute. The statute doesn't say much more about who are executive, administrative, and professional employees. It certainly doesn't say anything about a salary level or how employees are supposed to be paid. But nevertheless, it does delegate authority to the Department of Labor to interpret what these terms mean. So next slide, we'll look at really what the Department of Labor has done with it. With this grant of authority, we'll get into a little bit more nitty-gritty. But the general idea here is that the Department of Labor has set out to define an EAP, executive, administrative, professional employees, in two ways. Number one, predictably, it's talked about duties. This idea that employees performing duties that fit the mold of an executive, administrative, or professional type will fit the bill. But that's not it. The Department of Labor has also infused in the exemption definitions requirements about pay. This idea that for the vast majority of employees who might qualify for these exemptions, they must be paid on a salary basis at least a certain level. And the salary level is what's really being changed here. To really hammer it home, so we've got on this slide this idea that, look, you could have a CEO clearly performing the types of duties that someone would consider to be exempt. But if they're paid, for example, on an hourly basis, they would not be exempt under the statute and under the regulations. Because the idea is that you've got to have both. You got to have the duties, you got to have the pay. Likewise, if you had someone performing, exclusively blue collar type duties, cleaning, routine manual type work, even if they're paid an exorbitant salary, $500,000 a year, or whatever it may be, they also won't be exempt. Because while they have the pay, they're paid a salary, and they're paid a very rich salary at that, they don't have the duties. You got to have the duties, you got to have the pay, but the real focus today is on the pay. That's what the Department of Labor is changing. Next slide, please. So drilling down a little bit further than just the color-coded grids. So when you look at the rules that the Department of Labor has put out there defining these white-collar exemptions, these EAP exemptions, essentially they've got three requirements. The employee, for the executive, administrative, and professional exemptions, subject to a few exceptions, needs to be paid on a salary basis. Generally, that means a predetermined weekly amount that you're not reducing based on the quantity of work the employee does or the quality of work that they perform. Furthermore, that amount that's paid on a salary basis has to be at least a certain amount. As of present day, until July of this year, which Ariel's going to talk about and Scott will as well, that amount is $684 per week. There are some exceptions to that. So that's requirement one. Requirement two, salary basis at least a certain salary level. And then on top of that, the employee has to perform a primary duty. Their most important duty has to be that of an executive, administrative, or professional employee. And the Department of Labor's regulations define what that means. They define, what do executive duties look like? What do administrative duties look like? And what do professional duties look like? There are other exemptions as well. We'll talk a little bit today about this idea of the highly compensated employee exemption. Essentially, what the Department of Labor says right now is that if you have an employee whose compensation is sufficiently high, and as of today, that means just over $107,000, inclusive of the minimum salary, inclusive of the $684 per week, that person can fit the bill for exemption with a very lenient duties test. Basically, the Department of Labor is telling employers and Department of Labor investigators and courts, you don't need to look that hard at duties if you've got an employee who's earning at least this amount on an annual basis, $107,000 and change. Next slide, please. The last thing to note before we really get into, I think, what everyone's here for, which is to talk about what's changing. It's important to remember that some states have their own overtime laws with their own overtime exemptions. California is like the obvious example that everyone talks about, but as we talk about all the time here when we're advising our clients, there are a lot of states out there that are doing their best California impression these days. We've seen a lot more restrictive overtime laws come down the pipe in places like Colorado, Washington State, New York, Pennsylvania, and a smattering of other states. One thing to keep in mind relevant to the topic today is that some states, again, have their own exemptions. And even more important than that and relevant to our topic, they set salary levels for exempt status that are higher than the federal level. Not just higher than the federal level today, but higher than where the Department of Labor has said the salary threshold is going to go in July of this year and then January of next year. We've listed a few examples here. You've got states ranging from California to Washington, Colorado, New York, all of which already have salary thresholds on the books, well into the $50,000 range, if not the $60,000 range. The last thing I'll mention here is that states differ in other areas as well. I mean, some states define, well, what does it mean to do executive duties differently than the US Department of Labor does? And the last thing worth noting here is that some states that have overtime laws don't recognize certain exemptions that the Department of Labor does. So for example, like I mentioned, the highly compensated employee exemption or the HCE exemption on the prior slide, some states that have overtime laws like California don't recognize an HCE exemption. So something that's really important is not just to keep an eye on where the federal law is going, but if you've got employees in different states, it's really to make sure you're aware of any state law variations compared to the federal law. With that, we will get into the main draw here, which is talking about this new rule that's been published. And for that, I will turn it to Scott.
Thanks, Kevin. Appreciate it. And yeah, you can see right there the DOL is pushing to 58,656. That number is kind of in the mix with the state thresholds that Kevin just referenced. If we go to the next slide, we'll see that the new rule is focused on the salary level. Kevin mentioned the three requirements of salary, threshold, and duties. Some thought maybe the duties test would be an issue here, but it turns out not so much. Really, it's just the goal of DOL to raise this salary threshold, which is often seen as sort of a gatekeeping step in the evaluation of classification here. The DOL has done nothing with that duties test. They think it's well known and easy to understand, which I'm sure we can all not agree with. DOL, we've seen litigation like the Helix case, which I think Kevin mentioned earlier, and we'll talk about again, which involved, well over 200,000 per year in payments, but overtime was successfully claimed. So, we'll see if down the line DOL takes another shot at this, but for now we're just looking at salary. And it's a significant change in the salary for the EAP exemptions. In the first year, DOL estimates that more than 4 million, about 4.3 million workers will be newly entitled to overtime. And it's not just the EAP folks, that accounts for the HCE highly compensated folks that Kevin also mentioned. There's going to be a shift basically from costs on employers to deal with regulatory familiarization, adjustment costs, and management costs, and that'll transfer $1.5 billion to employees through these changes in the salary threshold and making these new folks eligible for overtime. That's DOL's take on the situation. Also, DOL thinks this will reduce the risks of misclass, increase worker productivity, reduce turnover, and increase personal time. Occasionally you catch something in a DOL rule and it makes you wonder in reality how something will work. And one of those to us, I think, would be how do you increase productivity while also increasing folks' time, personal time? Because it seems like if you're increasing productivity, you're working harder because maybe you're making more money on OT. That would actually reduce your personal time. But that's for all of us to figure out as this rule maybe gets implemented. Also unclear is how this is helpful at a time when we're looking at certainly more remote work, not within the confines of a rigid work day, start and stop from 9 to 5. things have changed even before the pandemic, but certainly through the pandemic, there's been a revolution in remote work. And, you know, beyond that, we can also look to, and this is a whole nother presentation, the influence of AI on, you know, streamlining and commoditizing certain types of work. So all of those could impact how people do their jobs, where they do them, when they do them. And maybe this is a rule that's a little bit short-sighted in not addressing some of those changes through a rethinking of the duties in addition to the salary levels. If we could go to the next slide, we'll see that, and this is just kind of a historical overview of how this has changed. Kevin mentioned the 684 per week. That is the current required salary. And you know, the level of 35,568 per year. That is where we are with the 2019 rule currently in effect. It was in 2016. Obama administration made an attempt to raise that higher. Did not happen, and we'll get into that a bit more as well. But here now we have this sort of biphasic approach where initially in July, we're going to see a more modest increase to 844 a week. And that is also pegging the threshold to determine, or the percentile to determine the threshold at 20% in the lowest paid region, which is currently the South. But then it jumps in January to over $1,100 per week in salary and pegs that at the 35th percentile in the lowest paid region, which is approaching what the Obama era rule attempted to do at the 40th percentile. The Trump rule, as you can see, is again pegged at the 20th, and it looks a little bit like the two-phase approach here may be designed to maintain at least that first change, even if legal challenges come, and, you know, identify a way to, you know, aim for the sky with that second January change, but maybe land in this middle ground of 844 a week with 43,000 a year, which would be a more modest increase of, you know, a little between 7 and 8,000 a year on the salary level, but still, you know, important and significant. We also, you know, want to pay attention to that auto increase. This was something else that was, you know, proposed in the and actually issued in the final rule that was enjoined under the Obama administration. But it's returned here to sort of attempt to align with changes over time in economic changes over time and account for those and potentially keep these thresholds in line with economic status of the time. But if we go to the next slide, we can think about what that might do. With an auto increase every 3 years based on that 35th percentile of earnings, it could actually accelerate the increase in the threshold because, and again, let me say before I get too into this slide, this is not to scale. This is just to show you. If you keep going, actually, Kate, I think there are some additional animations, and I'd just like to put them all up there. So you'll see, you know, as the threshold increases and pinning to that 35th percentile, you're going to push comp higher, and you're going to have the lower paid earners potentially shift to hourly status or have a higher salary. And so you start to drop those folks out from that 35th percentile. The 35th percentile keeps moving faster and faster forward. And you're going to wind up in a situation where that threshold could jump really, really significantly. You know, you can think of heats in a race where the fastest runners advance, and those times are going to be faster. The faster the folks get, the average time is going to be faster when you eliminate slower runners like myself from those heats, and you have faster people like Kevin and Ariel, you know, taking the lead in that race. What else you might see here is pay compression, right? As folks have this increase in their salary at potentially, you know, lower levels of exempt employees, their supervisors, their managers are going to now be kind of in the same band. And you're going to have to think, do we also have to extend them up to maintain a gap from the folks who are actually doing higher level supervision rather than kind of compressing the pay bands and having folks who are supervising get paid almost, the same amount as those who are being supervised, who they are supervising. So that's an issue to look at too, and it's something to consider moving forward as these things escalate and the auto increase potentially takes effect. If we go to the next slide, I believe, Ariel, you're going to chat about the highly compensated folks.
Awesome. Thank you so much, Scott. So yes, in addition to the EAP additional increase of thresholds, as Kevin and Scott have mentioned, the highly compensated threshold is set to increase both on July 1st and January 1st, 2025. On July 1st, it's set to increase to 132964. And as Kevin had mentioned in his earlier slides, there's still a salary basis requirement. So that will still be an 844, which is the EAP salary basis requirement. And then this is set to reflect the 80th percent of high, wage earners nationally, which if you look historically, based off of where we are currently, is the same percentage of where the 107,000 was set for. And actually, interestingly enough, it's lower than that Obama era rule that was enjoined in 2016. And then just like the EAP rules, it's also set to increase again on January 1st, 2025 to 151,164 with a salary basis threshold of 1128. And this will actually increase it to the 85th percent of workers nationally, with auto increases just like the EAP for every 3 years. As Kevin mentioned in his earlier slides, there's still a duties test for these folks. It's much more lenient. And so we don't necessarily always focus on that duties requirement like we do for the EAP, but it's important to keep that in mind because oftentimes we'll see folks that have a lower kind of salary threshold, maybe closer to that 884 or 1128, but we'll make it up in a commission or a bonus at the end of the year, as a lot of highly compensated folks do. So important to check that salary threshold and also the job duties, but keep in mind their compensation structure can be quite different than your typical EAP folks. So important to keep that in mind. And then on the next slide, we'll talk about things that didn't change from the proposed rule. So if we have any kind of wage hour nerds out there who actually read the proposed rule, in August 2023, that proposed rule, the salary thresholds are different than they were that came out in April, but there were things in the proposed rule that did not come into effect. So one of those things was that the Department of Labor said that they were going to increase the salary basis thresholds for anyone on the line that has employees in Puerto Rico, Guam, the US Virgin Islands, American Samoa, or the Northern Mariana Islands. Right now it's lower than 684, it's at 455. The proposed rule had an increase, and that increase will not be part of the final rule. We suspect that there might be a forthcoming change to this. We don't know what it will be or when it will come out. We've gambled on when the final rule will come out, and we were wrong on that. So we don't know when this will come out. So something to keep in mind that that amount has not changed. And then they also had something in the proposed rule that said that the motion picture industry, which is important for us Atlanta folks as we have a booming film industry, that there would be an increase for their salary basis threshold as well. That also was not made into the final rule. So that will stay into current effect. But we suspect, again, that there might be something that's forthcoming. So if you are in those industries, certainly keep your eye on the pulse for that one and we'll keep you updated, but something to keep in mind. And I'm going to pass it back to Kevin and to Scott to talk about the challenges that we suspect we will face in the next few weeks, or maybe even as soon as today, who knows? So I'll pass it to Kevin.
Yeah, thanks, Ariel. Just very quickly, we've tried to answer some questions in the chat. One, I should have mentioned up front, these are definitely not the only exemptions that the FLSA and the Department of Labor through its regulations recognize. There's a laundry list of other exemptions that employers rely on depending on the job and the industry. The EAP exemptions or the white collar exemptions are unique in that they're the most popular. They're the most relied upon. They're the exemptions that employers are most focused on. There are other types of exemptions with different requirements for different types of employees. For example, someone had asked about sales. There's a separate exemption from what we're talking about called the outside salesperson exemption, which is like a very generalized matter. It's for employees who are customarily engaging in sales outside of the employer's business and also outside of their home. So they're on the road making sales. The FLSA and the Department of Labor recognize an exemption for that type of employee. There's an exception to overtime for certain employees in retail businesses who earn at least half of their compensation through commissions. Those exemptions are not changing as a result of these rules, but just like the EAP exemptions we're talking about, they definitely require a sort of exacting analysis to determine if the employee you're trying to rely on that exception or exemption for, in fact, fits the bill. So we're not covering every exemption that the FLSA's got. We're covering the main ones. With that said, and next slide, please. So just looking at the challenges ahead, HR and payroll leaders and those who advise and assist them who've been doing it for a while will no doubt remember the saga that was 2016, when the Obama administration's Department of Labor not only proposed but implemented, had a final rule that they'd published doing similar stuff to what this new rule does. And days before it was set to take effect, after many employers had already planned the changes they were going to make and in many cases communicated them, a federal judge in Texas enjoined the rule, said it could not go into effect, and the rest was history. And so without question, there are a lot of employers, HR professionals, payroll professionals who are asking questions like, well, are we going to see similar challenges here? And the short answer, yes, we are going to see challenges. How they play out, we don't have a crystal ball, just like we didn't in 2016, but we do expect some challenges, and some challenges are already underway. So we'll talk a little bit about those now. Next slide, please. So, just like before, we're expecting challenges, just like we saw with the Obama Department of Labor's rule. We expect to see challenges to the Biden rule. It's worth noting, in the rule that the Department of Labor has implemented now, they include a severability clause, which basically says if any part of what we're doing here is deemed invalid or an overreach by a court, the rest of the rule stays in effect. So like if, for example, the 3-year automatic increase is deemed invalid by a court, what the Department of Labor is trying to do is to say, well, look, the rest of what we're doing, the July increase and the January 2025 increase would still stay in effect. So they've got this kind of safeguard or attempted safeguard at the challenges we might see. But getting down to it, what are the challenges we might see? One, which I'll talk about on the next slide, just not yet though, is a challenge saying that the salary rules that the Department of Labor has issued are essentially exceeding the Department of Labor's authority, that it's going further than Congress envisioned in delegating authority to the department to define what it means to be an exempt employee. The other challenges are kind of a subset of that. So that first challenge is like the most extreme, saying you don't have authority to do like any of this, any of what you're doing. The other challenges that we expect are kind of one-offs of that. We expect to see a challenge like we did in 2016, saying that the Department of Labor, maybe it's got authority to set a salary level, but this is too high. It went too far with this one. Likewise, you'd expect to see a challenge that's really going for it would say, the automatic increasing, that this kind of 3-year automatic escalator is exceeding what the Department of Labor is allowed to do, that it should have to do that through some sort of regulatory process, not by just setting and forgetting a 3-year automatic increase. Scott will talk about this challenge to whether the Department of Labor can do this when it doesn't have a confirmed secretary in place. And then, of course, a lot of employers are understandably asking, well, what does the upcoming presidential election mean to all this? We've got a new president in office, who knows at this point, but what would that mean for the rule? So we'll dig into these challenges just a bit now. Next slide, please. So the first challenge I want to talk about, it's like the biggest one. It's the one that it has the most potential impact. Whether it's going to succeed or not, who knows at this point. This one stems from this Supreme Court decision from last year and a decision called Helix Energy Group versus Hewitt. The case involved, like, very long story, very short, an employee who earned well in excess of $200,000 per year, but it was paid on a daily rate. You get X dollars for each day that you work. The Supreme Court in that decision, it's the main thrust of the decision was that the employee, even though he was exceptionally highly paid, was not exempt because the court essentially said, look, a day rate's a day rate and a salary is a salary, and you need to be paid on a salary basis to be exempt. But what's really relevant now, and will be the focus of litigation to come, is what came out of the dissenting opinion in Helix, or the dissenting, the dissenting write-up from Justices Kavanaugh and Alito. And what the justices said in their dissent is that the statutory text, which we looked at, on the first substantive slide, says, has Congress telling the Department of Labor, you can define executive, administrative, professional capacity. And what the dissent is essentially saying is, when you talk about defining capacity, capacity means duties. It means, what does the employee do? And the dissent would say nothing about the term capacity, this term that Congress used to say Department of Labor, go define it, suggests anything about how someone is paid. It suggests more about what they are doing. And so what the dissenting judges said in this opinion is, more or less, bring us that challenge, because we would look forward to hearing it. That kind of challenge is already happening. Over the past couple of years in Texas, all over again, it feels like, there has been a piece of litigation filed by an individual named Robert Mayfield. He owns a bunch of Dairy Queens, essentially challenging the Department of Labor's authority to issue even the current salary level, saying in line with this dissent that it goes too far. The Department of Labor doesn't have authority to do this. The Mayfield lost at the district court level on that one. The court said, no, the Department of Labor has the authority to do this, and essentially dismissed the case. But that decision is now being briefed at the Fifth Circuit Court of Appeals. I believe it was fully briefed as of about 3 weeks ago. And so we'd expect to see some movement in that case over the summer. And regardless of what happens, it would be surprising not to see, or it would be surprising if who's ever on the losing end of that one didn't go for Supreme Court review, given the political football that this has become, and given what the dissenting judges put out there in Helix last year, saying, does the department have the authority to do anything with a salary and defining executive, administrative, and professional capacity? So with that, I'll turn it to Scott on the next slide to talk about a few of the, I don't know if we'd call them more subtle challenges, but kind of more one-off challenges that we're expecting to see.
Thanks, Kevin. Yep, I'm nothing if not subtle, so it makes sense that I would tackle this next piece here. The challenges that we may see, obviously, to the salary amount and auto increasing feature align with similar challenges that happen in Texas with the Obama rule, as Kevin alluded to. And some of those pieces that Kevin spoke of with Justice Kavanaugh's concerns showed up then as well. Is this something? Is the salary threshold even something that DOL can sort of regulate? And in 2016, the Texas federal judge determined that, and I think we referenced this previously, the threshold was so high, it really was no longer serving the gatekeeping function that the salary level threshold has traditionally served. And so it was kind of beyond what DOL could do here. We did talk earlier about how the Obama era rule pegged the salary level amounts to the 40th percentile for EAP and the 90th for the HCE exemption, along with this automatic updating feature. President Biden's DOL has gone with 35th and 85th. Don't seem that different, seem a bit higher, a bit closer to 40 and 90 than to 20. And I forget what the number was for the Trump HCE, but they're closer certainly to the Obama era that has been found, never went into full effect because of the injunction from the Eastern District of Texas. And as Kevin referenced, it was a lot of fun, and I think employers are probably having deja vu or PTSD this time around, wondering if they're going to face the same ramp up to then not have to comply with a rule that gets enjoined. So the court, when determining that the Obama era rule did not work, basically said, again, the department doesn't have the authority to use the salary level test that will effectively eliminate the duties test, because as Kevin pointed out in the statutory, or in the language that he referenced, you know, it's the capacity which people read as duties, not salary level. You know, there is no provision in FLSA section 213A1 for a salary requirement, and it's been used, but you know, to identify as a test to identify what Congress meant to exempt, but you know, not necessarily, it shouldn't be sort of the only step. As we talked about, there are really 3 requirements to meet the exemption. And, you know, DOL would risk excluding workers performing exempt duties by raising the level too high. So the court didn't actually address the auto updates, but we do obviously know that that provision was included in Obama era and the current Biden rule, and certainly a number of entities are set to challenge that as beyond the authority of DOL's rulemaking, presumably outside the the Administrative Procedures Act, for notice and comment, because you're making a substantive change to the rule without actually going through rulemaking. But you know, the matter here, as Kevin mentioned, was appealed, but never really resolved, and sort of the 2019 rule has kind of taken over as the relevant rule. But we're looking to see that re-upped again with this similar rule in place. I know last week, actually, Acting Secretary Sue was testifying before a House committee, and she said, you know, this rule is different. This one's legal, and you're going to have to see how they make that argument, because there do seem to be a lot of similar touch points between the 2 rules. We don't know how another court will look at this. You know, this is one district judge in Texas who had this opinion about the last rule, and so, you know, we should probably buckle up for some litigation to see how this will all shake out. If we go to the next slide, I did just sort of reference the fact that the Secretary of Labor role is technically empty at the moment, with Julie Su serving in an acting capacity. And that's something that in these hearings recently, and more generally in challenges not only that we anticipate to the OT rule, but in past, you know, shots fired against, for example, the independent contractor rule, folks are going to question whether she has the legal authority to issue these kinds of rules in her acting capacity. The department certainly believes she does. There was a GAO opinion that she is legally acting under what's section 552 of Title 29 of the U.S. Code, which is specific to the Secretary of Labor position, and when that position is empty, the Deputy Secretary assuming those responsibilities. Typically, the Federal Vacancies Reform Act would be what governs here, but there is this, you know, Republican House members refer to it as a loophole. As you might imagine, Acting Secretary Sue disagreed with it being a loophole, and GAO, again, also found that she is legally acting in fulfilling the roles of the Secretary as the prior Deputy Secretary, and in fact, still the nominee, though it doesn't seem like there's a lot of urgency to push her nomination forward. And we can trust that with some of the moderate Democrats in the very, very closely divided Senate, she would have a tough road, or else we likely would have seen some effort to push her through. So, you know, we've seen in the past, just historically, that regs have been issued by the Labor Department when acting secretaries are in place. Nonetheless, this is a different environment and a new issue. So that is another argument that potentially has legs against these kinds of rulemakings, though it is something that, again, has happened previously. So we'll see. And, you know, these are also things that if the administration flips, you have to think about that too. You know, careful what you wish for if you limit the authority going forward. But, you know, we're in the moment, and so we'll have to see. Then one other thing, we've mentioned the independent contractor rule. You know, that kind of rule, as well as, you know, other rulemaking going on to the DOL, we can't look at these things, to me, in a vacuum. You know, you're looking at the independent contracting rule as something that involves a classification analysis, as well as The rule here, the OT rule, involves a classification analysis. The independent contractor rule may be a little bit more amorphous with the 6, 7 unlimited steps that you have to consider for the totality of circumstances. Here you do at least have a threshold plus the duties test, but there is a bright line in that salary test. The question being, is it appropriate and is it valid under DOL's authority? So as Kevin also mentioned, if the White House changes hands as a result of the November elections, I think we could see the withdrawal of both of those rules, the OT rule, the independent contractor rule, the Trump independent contractor rule. A lot of folks in business, on the business side of things in particular, preferred that it provided clarity and sort of some keynotes and keystones to sort of guide your classification analyses by. Similarly, obviously, President Trump's administration issued an OT rule that, while under litigation, could be somewhere where a new administration, a second Trump administration, might go back to the thresholds and to the processes, the percentages in play that happened in 2019. So, this is the interesting environment that employers and their lawyers find all of ourselves in. And after I read on the next slide the CLE code, Ariel will then jump into what employers should be doing to address these changing and fluid times. So you can see there is a QR code which you're able to use here if you want to complete a digital attendance form for CLE. We also will provide you, as needed, the code, the CLE code. It is SS, as in Seyfarth Shaw, 5858. Again, SS, Seyfarth Shaw, 5858. So you can scan that QR code to submit your CLE request using that code SS5858. And with that, I will turn it over to Ariel for some practical thoughts on how employers should be planning for this new rule if and when it survives legal challenge.
Awesome. Thank you, Scott. Next slide. So in the next few slides, before we kind of wrap up and allow time for questions, we're going to talk about the practical implications, but also the opportunities that this rule presents for all of us as employers, and take the information we've learned or that you've been reading about in the last few weeks and how we can apply it to our business and inform our stakeholders. Next slide, please. So the big question a lot of people are asking is, what should we be doing? When we had the Obama era rule in 2016 come out, they gave us about 6 months to prepare, and this is quite a tighter turnaround. We have about 7 weeks now, assuming the rule goes into effect, to go ahead and start thinking about those employees who are making between 35 and 43 and some change. And then we've got another fast, turnaround for about 6 or 7 months to then be prepared again for that $58,000 jump. So we really need to critically be thinking about our exempt employee population. So as, kind of a first step, what we'd recommend that employers do is take a look at your exempt employee population. We recognize for a lot of employers that could be thousands upon thousands of employees. So how do we break that down? A good rule of thumb is kind of, let's first look at those employees who are making, between 35 and 43. Assuming the rule goes into effect, those are the employees that will need to be reclassified, presumably first. And then, we want to look at employees under 60,000. All of that being said, this really provides, a wonderful opportunity for us to be looking at job duties as a whole. One thing we always think about when we have these rules come out is that it really presents a golden opportunity for us to look at employees' compensation and their job duties holistically and think about whether changes need to be made. Oftentimes we have employees who need reclassification, and those communications can be hard to give to employees. Culturally speaking, for some reason, employees like to be classified as salaried exempt, despite the fact that this rule is really intended to benefit employees. And so this gives us a natural conversation point to say to employees, there's rules out there that are changing, and as a result of that, we're looking at the business, we're looking at the structure of employees, and we're making some changes. So, this really can be a positive thing that's happening for businesses, even for those employees making more than 60,000, in a time when we can reclassify those employees in just kind of the purview of this new rule. It also gives us an opportunity to assess other exemption-related issues and look at, non-exempt employee rules generally speaking, and kind of review all of our policies and practices around that. So this can actually be a really positive thing. Even if the rule does or doesn't change, it gives us this opportunity as the forthcoming rule is coming out to look at those rules. So in the next few slides, we talk about kind of a strategic plan as to how we'd recommend kind of overall looking at these rules. So on the next slide, we'll start to discuss that. So the first thing we want to do is really get the right people in the room. You all have joined us today and we're excited about that, but you may not be the totality of the decision makers at your business. And so getting those right stakeholders in the room, teaching them about the rule if they don't already know it, and thinking about who we might need to talk to, who manages specific roles of exempt employees making under 60,000. That's the right buy-in that we want to start getting now if we already haven't done that. Again, we have a quick turnaround, so we want to start thinking about, how those changes are going to come into effect. And then the second step of what we want to do is really understand our workforce, get an accurate picture of who our exempt population is, what they're making, what their general responsibilities are, what their compensation is, and then also what their locations are. Certain locations have, as we've mentioned, higher, requirements from a salary basis threshold. And so we want to really understand our workforce and how what these changes that we might make might affect the population from both a compensation and budgetary standpoint, a cultural standpoint. And so getting a good understanding and grasp of our workforce is important. And then we want to start to triage that. So once we have a good landscape, we want to start to look at roles that likely need to be classified or reclassified rather. And so salary is obviously going to be indicative of that, but also job title can certainly be a good, ringing bell for that. There are roles that are often litigated just because of job title alone. And so those are roles like assistant managers or account executives, roles like that we want to, put in that reclassification look at. And then unlikely to ever be reclassified. Those are probably the roles that are making over 150. Your more executive roles. Those are roles now we've kind of got, black, white, and then we've got that gray area, ones that are making maybe between 60 and 100. We want to put those in the grayer territory. And so once we begin to triage and start to look at those roles, hopefully it becomes less burdensome and we start to develop an action plan. And at Seyfarth, we've obviously been preparing for this role for, almost a year now. And so we've really fleshed out our model templates and our books and our communication plans, and we have those ready to go. So we'd certainly recommend, the strategy. We've been thinking about it for quite some time. We'd recommend, reaching out to me or Scott or Kevin or your favorite Seyfarth attorney, and we can help walk you through this process and this strategy and give you sort of model templates and communications that you can speak with stakeholders and you can start to figure out how these triages apply to your business. We have all of that ready to go, and we can help tailor that for your business. And then on the next slide, we'll kind of talk about next steps. So then once we kind of have that triage and we have that understanding of all the jobs in our workforce, we want to start to plan a review process. We want to ensure, with that 7 weeks that we might have here, that we do have adequate timing to really review the roles, think about their job duties, look at the job descriptions, speak to their managers, speak to their supervisors, really understand those roles, and then start to identify changes that need to be made and prepare to execute those changes. So are we going to start, raising potentially some salaries? Are we going to convert people to hourly non-exempt or salary non-exempt, or pay people on a day rate, potentially eliminate a role, potentially, move that role and split it up against, many independent contractors, assuming they meet the independent contractor test. But we need to think about how those changes are going to be made, which are going to affect our business. And then once we start to figure out how we're going to pay people, there's a downstream that comes from that. Once we're starting to pay people, that may affect our budget. And so we may, change our bonuses. Or unfortunately, we may not be able to offer the same benefits that we did before. And so we have to think about how we're going to communicate that to employees. And then we want to train employees. So the goal of all of this from the Biden administration was that we'd have more employees, as Scott mentioned, 4 million plus people who are now going to be part of the non-exempt workforce who now will presumably need to understand how they need to keep their time, how they might receive overtime, how they're going to potentially get meal and rest breaks. And so we want to make sure those employees have a deep understanding of their, responsibilities for timekeeping, and also their managers and supervisors know how to advise their employees to track their time to make sure they're taking their meal and rest breaks. And then we also, from a back end, want to make sure that whatever payroll and timekeeping system we're using, or the good old time cards, are ready. We're prepared by July 1st to implement that so that we do have those good time and pay records, should we ever face litigation or a claim or complaint. And then, there are tangential impacts that come from having a non-exempt workforce or a larger non-exempt workforce. There are a lot of wage hour laws that apply to non-exempt employees. Think expense reimbursements, think deductions, pay transparency, wage thefts. There are fair work week and predictive scheduling laws that apply to non-exempt employees. So now we have this greater population of non-exempt employees, and these laws that we need to make sure we're, understanding from a state perspective and a federal perspective that apply to them, and that we understand and now train employees in. You might not have had a non-exempt workforce in a particular state, but because of reclassification, now you do. And so we need to think about those tangential impacts. And then all that being said, we want to make sure once we figure out and flesh out the laws, we have a really good communication strategy behind that. We want to have a good, smooth transition. We want to, make sure that morale is positive. At the end of the day, culture is so important, and we want to make sure that employees, if they're concerned about their pay or concerned about their time or don't understand something that's, happening potentially rather quickly, we have a good communication and PR plan surrounding that. And as I mentioned, we have, ready to go communication plans for that we can help you tailor for your business that really help flesh some of this out. So on the next slide, I know we have about 8 minutes, and I wanted to make sure we had time for questions. I'll open that up. I know Kevin's been answering them in real time, and I appreciate him doing that, but I suspect there are some other questions that might come through at the end, so I'll leave some time for that. But thank you for your time. I really appreciate it.
Ariel, I just wanted to pick up on your comment about communications, because I think there was a question about sort of how to sort of manage the fact that folks may be classified who were formerly exempt, may be now classified as non-exempt. And I think that goes to communication, because there could be some, certainly we talked about the pay compression issue, but there's also an issue of morale and, how you're going to address that with folks who, view that exempt status potentially as a badge of honor or, a career achievement. And, with more folks falling under the threshold and being eligible for overtime and potentially being non-exempt, you're going to wind up in a space where that achievement isn't unlocked. You're back to, maybe you're looking at yourself as sort of taking a step back in your career, which it's something that isn't necessarily a legal question, but it is attendant to this regulation and some of the changes that may need to happen based on it. I see someone said, yes, they hate recording time, which, that goes both ways, right? So the employees are going to hate recording time, but also the question becomes if you're no longer salaried exempt and you used to answer questions after, quote unquote, after hours and you weren't tracking time. Now the employer is going to need to be aware, are you doing that still at 8 p.m. and is your day not really over? And does that time need to be recorded? And how can we do that? And does AI come into play, and is it biased? And I'm leaving that all to Kevin, because AI is, I'm worried about it taking over. I mean, literally like the robots coming. But I think all of those issues are things that are practical implications of these reclass issues that may present themselves.
Yeah, and I would add, it's a really good point, both Scott and Ariel. I think that you're jumping off, the communication is so important. I think it does help, when we've got regulatory change to blame things on. It doesn't mean people aren't upset, but at least you've got your why, or at least a part of the why there. One thing that I will say, though, and probably less so for this July increase, more for the January increase, which I think is going to impact a lot more employers if it goes through. Ariel kind of touched on this. I mean, a lot of employers could have not just new, teams of non-exempt employees, but managers who have never managed non-exempt labor or non-exempt staff. And, you could have the best ever. I mean, you could partner with this dream team of lawyers and have the best communications, and everything's just like as clean as it can be about who gets reclassified and when and what they're told and so on and so forth. But the compliance challenges really start once that's done. If you've got employees who, to Scott's point, continue acting like they're salaried exempt, working late into the night, and worse, like timekeeping doesn't matter to me. I'm just going to record it, 8 every day, 40 every week. I mean, at some point, that becomes a big issue. And as a lot of employers have found out the hard way, it's not hard for that sort of thing to kind of blow up. And so I guess to kind of put a fine point on it, what keeps me up, it did in 2016 until the court gift wrapped an injunction on the rule days before it took effect, is so much energy on the communication and not quite enough on the practices and habits that need to change after it. The other thing I'll just add is, for some employers, if you've not looked at exempt classifications in a while, even if like it's not totally, not driven exclusively by this rule, this can be a good opportunity, to look at jobs you've not looked at in a while. And if you do need to make changes, to have some cover to do so, to say, look, sincerely, we're looking at how we do things. We're always trying to make sure that we're on the up and up. And it's even more important because we're at a time of regulatory change. That's an explanation that you don't have all the time that you do have now and for at least the foreseeable future.
Yeah, the internal auditing piece, I think, is big, Kevin, to your point. I mean, just to make sure that you can take an opportunity, and again, the secondary, again, blame it on the government, right? We saw that all the time in COVID, when vaccine regulations were coming out. We got to do it, the government says. So this is a similar issue, I think. Ariel, there's an HCE question that I feel like maybe you could take the lead on.
If someone's basing for bonuses during the year, make them. Yes, so the question is regarding annual base salary of 100K, but eligible for bonuses during the year. So we can factor, Kevin, correct me if I'm wrong, I think 10% into bonuses. But that number is presumably changing to 132 and some change. The most important part is that the salary basis threshold, which will be 844 starting July 1st, is met. And then additional amounts can come through bonuses and other commission plans.
Yeah, and just to touch on that, so for the minimum salary level, that's right. It's 10% of the minimum salary can come from non-discretionary bonuses and the like. For that highly compensated employee exemption, right now it's $684 per week has to be paid as a salary. On July, it's going to increase to the numbers that Ariel's laid out. The balance, the rest of it. So if you paid only right now $684, that's 30 something and change. The remaining 70 something. Lawyers are terrible at math, but the remaining 70 something can come from non-discretionary bonuses and non-discretionary pay, like commissions, written incentive plans that specify how, when someone's going to be paid. What it really can't come from is the discretionary, like, we just saw that you were below this line, and so here's some money. That's really not going to cut it under the current rule or under the revised rule.
Well, I started this thing, so maybe I should end it. I don't see any additional questions. But if there are any that we missed, scrolling through the chat, we will get to review those after, and we will try and connect with you individually on your question. As I believe most folks who asked whether the deck will be provided, it will be. So you will get a copy of the slides. And again, as we noted, we are well prepared and well situated to chat through these issues with you. So please feel free to reach out. You'll have, again, our contact information is on the screen right now, but when you get the deck, you'll have it as well. We appreciate everyone's time today and investment in working through these issues, and we'll be paying attention to where they go and what challenges we face, both in court and on the ground in executing. So thanks again for everybody's participation. We appreciate it. Have a good day.